Ladies and gentlemen, welcome back to the Indie Zone podcast. My name is Kathy. If you have not yet had an opportunity to listen to our last episode of the Idaho versus Kohberger podcast, I recommend that you do because it's going to give you some background on what happened yesterday, September 23rd, 2025, when 7 documents were filed on the court docket in Idaho versus Kohberger. I wanted to call your attention to certain of the documents that were dropped onto the docket yesterday that are dated September 19th, 2025. And this is the state of Idaho and the defense's responses that they were court ordered to file by entry of Judge Stephen J. Hippler's court order of September 3rd, 2025, that gave them 16 days to respond. Therefore, their responses on the 19th of September meant that they waited until the last possible day to file their responses. And you can see them on the court docket. They are available as of yesterday. What was interesting to me as I looked at these 2 documents that I wanted to bring to your attention is that the defense response to the order of September 3rd dealing with providing objections or non-objections to 2 months worth of documents that were sealed during April and May of 2025. Every single response is sealed because what the defense did is they filed a motion to seal those responses, and that court order granting that relief is on the court docket. So therefore, whatever objections or non-objections that they may have had is under seal. That's the defense. The state, however, did not move to seal everything in terms of their responses. If you look at the court docket, you're going to see what the state did is they filed a response to this September 3rd, 2025 order directing that they provide their objections or non-objections to 2 months worth of documents sealed from the public, dated April and May of 2025. You'll see their first item, page 1, has to do with jury instructions being unsealed. State has no objection to having jury instructions that were filed on that date, first document in the series. You can see it on page 1, being released to the public. If you read through the next several pages, you're going to see, yes, there's some objections that they have raised and they give their reasons. What they've also done is they've had no objections to certain other documents being unsealed at this time. What they did, unlike the defense who filed a motion to seal everything that was granted regarding their September 19th objections and non-objections, what the state did is they included an exhibit asking to have certain specific items that are on that list sealed from the public, and the court did go ahead and grant that relief. So at this point, it's now 2 months since this case was closed, a case that went for a full 2.5+ years before it was closed on the 23rd of July, 2025. And I would, giving my opinion here, assert that the fact that the state would not object to many things to being released to the public, while the defense blanketly objected to everything that they responded to, is quite compelling to me. And I'm giving my opinions here pursuant to the First Amendment of the United States Constitution. This will now conclude this episode of the Indie Zone podcast. Thank you for joining us today.